What's wrong? Something serious? Is your interest failing in me? Sylvia, is it Ahuja?
I stand in a moment of great responsibility as we address the case of Nanavati versus State of Maharashtra. This is the case involving the tragic death of Prem Ahuja at the hands of Commander K.M. Nanavati has deeply affected our society. While the law must hold individuals accountable for their actions, it is also essential to remember the complexity of human emotions, love, betrayal, and loss that shape our society. As governor, I am ensured with the power of clemency and I have carefully considered the fact, the public statement, and the potential for rehabilitation. Commander Nanavatis has expressed deep remorse for his action and his crime was not premeditated, but a result of a moment of intense emotional turmoil. His subsequent conduct has shown genuine regret and many believes in his potential for change. As thoughtful reflection, I have decided Commander Nanavati's sentence be commuted. This is not overlook the gravity of his actions, but this recognize that the justice also be tampered with mercy. It is my belief that this decision offers a path for healing both for Commander Nanavatis and for our society. Thank you. The court is in session now.
Your Lordship, the Council on behalf of the appellant present before you to move the special leave to appeal under 136 of the Constitution of India, as there is a grave injustice barged on my client and there are the ends of the justice demands. In the case of Mustaq Hussain versus State of Maharashtra, it is said that the verdict of the jury cannot be set aside if there is no misdirection by the judge. This particular act of on behalf of the Sylvia had galvanized my client and he was under the condition of grave and sudden provocation as he got suddenly entorched with the fact that his beloved wife had an affair with Prem Ahuja. So the intention of my client was not to murder Prem Ahuja as it was just a tussle which had resulted 3 shots of bullet to be fired. Therefore, I, on behalf of my client, claim the defense of grave and sudden provocation and the act was merely an accident.
It's the time for the respondent to take his plea.
Your Lordship, the appeal on the behalf of the appellant shall be dismissed as there is no injustice barged on the appellant, Nanavati, and the justice to the departed soul must be served by rejecting this appeal and corroborating life sentence with rigorous imprisonment. To claim the defense of grave and sudden provocation, there must be consonance in the time period in which the act of provocation was done and the time in which the offensive act was committed. And there is enough pulling off period as the appellant had first dropped his wife and children in the cinema hall and then went to the ship and fetched his semi-automatic gun and subsequently went to the fact of Prem Ahuja, which implies that Nanavati's intention was to quench the thirst of revenge. And this petition shall be disallowed and no defense shall be entertained in this court of law.
Considering the facts and circumstances ascertained and considering through arguments proposed by the counsel on behalf of appellant and respondent, with austerity there shall not be any dispute over the hearing of this case of this court of law. Also, the consideration of defense of grave and sudden provocation and accident and misfortune which was mooted in this court shall not be considered as there is a substantial evidence of cooling of period of this accused. This certainly incidents that accused has sustainable and considerable intention and in the step of activities of offense was completed. Therefore, in the result, conviction of accused under Section 302 of the Indian Penal Code and sentence of imprisonment for life passed on him by the High Court are correct. In the result of conviction of accused under Section 300 of Indian Penal Code and sentence of imprisonment for life passed on him by High Court are corrected, and there are absolutely no grounds for interference. The appeal stand dismissed.
Hi. So I was going through the rules of interpretation or the rules of construction. So I came across this particular rule known as the rule of harmonious construction. So this is actually one of the most complex rules of interpretation or construction, which is actually or potentially a nightmare for the law students. So this particular rule of interpretation comes into play when or to resolve any kind of apparent conflict between different provisions of a particular statute or between two different statutes. This particular rule ensures or corroborates that none of the provisions or none of the statutes or its meaning get negated. So actually I had also come across or I was pondering about its application in a very famous case known as the Nanavati case, which was actually a very landmark case for both in context of both the constitutional law as well as the criminal law. So how can we apply that?
Why do you have to worry? Here am I to show you something. So, in the case of Nanavati, the rights to appeal ensures that a person convicted of a crime has the opportunity to challenge the legal grounds of the conviction. Similarly, the governor's clemency power are intended to offer mercy in case of exceptional cases, as we know, where the severity of the sentence of the accused might justify some relief. So, using the harmonious construction, I would like to show you that the Supreme Court had interpreted these two provisions in a way that allowed both the remedies to coexist. The accused can seek clemency from the governor, and there could be granted independently of whether the Supreme Court considers the appeal. If the appeal is successful, the conviction could be overturned, but if the governor grants clemency, the sentence may be reduced or commuted.
I would like to signify the difference between Article 161 and 136. As we know, Article 161 is for the governor of the state to pardon and commute, respite any individual sentence. Then we have Article 136, which gives the Supreme Court to grant special petition. Then it speaks to prevent conflicts between the executive and the judiciary, to prevent both branches conflict and to operate efficiently without any intervention between those branches.
The principle of harmonious construction concludes that when interpreting statutes, courts must strive to ensure that all provisions of the law are given with effect without rendering any part redundant or conflicting. This approach seeks to reconcile apparent inconsistencies by considering statute as a whole, ensuring that the legislative intent is upheld in a manner that achieves coherence and avoids absurdity.